What is a creditor and what is discharge of debts? Are there any debts that are non-dischargeable? Attorney Elena explains, a creditor is a natural or legal person to whom a debt is owed. In the example of a debtor being the person who borrows money from a bank, the bank is the creditor of the person who has borrowed the money. The creditor gives something of value to the debtor, and the debtor agrees to repay the creditor according to their agreement. Generally, the debtor and creditor voluntarily enter into the transaction, creating their respective obligations surrounding the debt. However, some debtor and creditor relationships are created by law. For example, a debtor-creditor relationship is created if the person is the losing defendant in a personal injury action, or a person fails to pay taxes. One of the reasons people file bankruptcy is to get a discharge of debts. A discharge is a court order which states you do not have to pay most of your debts. Some debts cannot be discharged. For example, you cannot discharge debts for child support, most taxes, alimony, most student loans, court fines, and criminal restitution and personal injury caused by drunk driving or under the influence of drugs. The discharge only applies to debts that arose from before the date you filed. Also, if the judge finds that you received money or property by fraud, the debt will not be discharged. The Bankruptcy Code recognizes that, for public policy reasons, certain debts should not be capable of being discharged in bankruptcy. Other examples of non-dischargeable debts include spousal and child support, student loans in the absence of undue hardship, and certain taxes and penalties. For more information and a free phone consultation, contact the law offices of Steers & Associates at 877-989-5661 or visit them on the web at steersbankruptcy.com.